Welcome back to Chapter 7. This is a year-long process to basically convert my dad's book into video so people who don't like reading can actually watch this. This chapter mainly focuses on his legal career from going to the patent office to private practice. He talks a lot about his cases. He did a heck of a lot of cases. So he picked out a few. We talked about a few that he considers maybe his most rewarding cases and more important. And some are kind of famous. You might have actually heard about these cases. So sit back and enjoy this piece of his life. So we're starting Chapter 7. Welcome to Chapter 7. We are opening up about, this is private practice of law between 1980 and 2012, and you leaving the government. So let's talk about, you're on your way out. What happened?
All right, let me just give a big over picture first of all. I said earlier that I really didn't have any particular interest in law when I went to law school, but I have to say that I always had an interest in what would happen in the trial room. Could I be a trial lawyer? And I had that opportunity in the government. But I had a really big time when I went into private practice. I went with a firm called Spencer and Kay. They had a big case about a steel mill that was trying to come into South Carolina from England, from Ashlow in England, to replace a worn-out steel mill that they had. This is a steel rod construction facility that they had built 30 years earlier in Georgetown, South Carolina. So it was a very interesting case, and because I had trial experience in this new firm that I went to, I was assigned to be in charge of the defendant side, Ashlow. They were blocked by a company in New England called Morgan Construction in Worcester, Massachusetts, who had patents who they said were infringed by what the Ashlow people were bringing in. Well, through a little fortuity and some hard work, I ended up in charge of the whole case. And in the trial in South Carolina, I convinced the judge that we should receive certain attorney-privileged documents because the other side had played games and not identifying them. And on the first day of trial, I received the documents, Federal Express, directly handed to me, not even by my opponent, at the judge's request. Give it to him, pointing to me. And I looked in these documents, and there was a document that showed that Morgan Construction, when it was trying to get the patent, kept secret that they had already gotten another patent on the very same thing, and they had done it years earlier. They shouldn't have even gotten that one. And the document said, the patent examiners just examined our case, and obviously that patent examiner doesn't know a lot about this art because he didn't find the Edwards patent. The Edwards patent was this company's other patent. And then he said to his cohort attorney, so we have a choice here. We can try to even make the patent claims broader and even get more, but we run the danger if we do that maybe this patent examiner his work will be reviewed by someone with more experience and they might find the Edwards patent. Or we can do nothing and we might just steal the cake. Steal the cake were the key words. So anyway, make a long story short, it became steal the cake trial, and I got the patent declared invalid on 7 different grounds and got attorney's fees that they had to pay all of the cost of my counsel's fees to us. It was a big, big decision, and it went up on appeal, and we won it there. So from that, I stayed. I was offered a partnership right away. I didn't know what the hell that meant. I had no interest in it. But eventually, I took a partnership. The first partnership meeting that I go to, Spencer and Kay. Spencer's talking about kicking Kay out of the firm. They've been partners for 30 years because Kay clearly has a little bit of a mental problem. And I raise my hand and say, does anybody consider getting Kay some counseling? And the answer was, well, we would, except that his wife is a psychiatrist and she's leaving him too. So I didn't like it. And I left with a couple of people and formed Lupo and Lever. And we had our first case. I was lucky enough to be selected by a high-speed printer company in California before the International Trade Commission, won that, and then was selected by word of mouth by Tandon Computer Corporation to fight off the Japanese companies that were flooding the market with double-sided floppy disk drives. Don't even exist on computers anymore. It was before the hard drive that you now see. And won that case. And
so you had some big wins, and one of the first wins you had is because you basically got this paper that was a smoking gun. It was like, I never understood why you'd ever put something like that into a legal communication on paper. Like, why would you ever write that out? That, hey, we got lucky, we got away with this. And then how did you even get that paper? It was an accident.
Well,
right?
It wasn't so much an accident.
They gave it, why would they give that to you?
Well, we got suspicious that something was going on because in one of the document productions, I found a handwritten drawing by one of their engineers that showed at a much earlier date that they had something that looked like this, and I tried to get it. And you can keep your attorney-client privilege documents from discovery if you identify them properly. They didn't identify it properly. I suspected there was something going on. And just took a gamble with the judge. He agreed and ordered the production. There's a lot to tell about that trial. I don't want to do because it was a wild trial. It was a lot of fun.
But it's one of your first big trials.
It was the big trial, first big trial.
So you go into private practice, you get a huge win.
Yeah,
and a slam dunk win.
Slam dunk win, and
then that sets your trial up that you're winning the next case and winning the next case and winning the next case.
Yeah, word of mouth,
track record.
Right. And what was more helpful was the fact that the 85 cases that I argued at the for the government and the 7 trials that I had there gave me the basis to walk into a law firm and them immediately give me responsibility in a case. Because even though I had no experience in private practice, I had a ton of court experience. And the deal I had with that first firm, Spencer and Kay, was if things work out in 2 years, we'll consider you for partner. Well, hell, they were beating down my door at 7 months after I won this case to be a partner. And I said, I don't know. Let me think about it, which was a shock. I don't know that anybody ever said to a senior partner in a law firm, I was offered a partnership. I don't know. Let me think about it. And he says, okay, you think about it. So a month later, he came back. He says, have you thought about it? And I said, yeah, I don't know. Well, let me think about it again. So after finally 2 or 3 months of not telling him that I wanted to take a partnership, he said, are you ever going to tell me whether you're going to take a partnership? And I talked to a couple of my colleagues, and they said, what do you got to lose? Do it. So I said, okay. And that was it. I didn't really know that partnership was a big deal. I was that dumb. And
so did you do it? Did you become a partner in Spencer
Yeah. And then I lasted for that year until, I think I told you I went to the first partner meeting. They're trying to kick out the name partner. Is this what partnership's about? So, it wasn't too long after that I started thinking about forming my own law firm.
Now, I remember when you formed your own law firm, and I guess you took some buddies that were working at Spencer and Kay,
right.
Littman and Lever.
Yeah.
And is that how you met these guys? And you stuck
well, no, I met them in the patent office.
They were government attorneys too.
Yeah, they were patent examiners and Jack Lever was at the Department of Energy as a patent attorney after his patent examiner experience. He's the one who told Jim Denny. Denny says, I got to hire somebody to run this thing. He said, you might want to talk to Ray Lupo. He's supposed to be pretty good. So that's how I got Jim Denny to know me from Adam when he walked in, but he had researched. And Lippman played basketball with me at lunch every day when I was at the patent office, and I got to know him there. And he was trying to get into something to do outside of patent examining, so interviewed him or had him hired at Spencer and Kay also, and then brought these guys with me later to form Lupo and Lever.
So how did you fund? I mean, a lot of attorneys, you're young, you're in your private practice. How the hell did you get money to do this when you're just coming out of all this?
This was very brave, or you can call it stupid.
Gutsy.
We had no clients. I left Spencer and Clay without a client. Even told Spencer, the head attorney, I'm not going out there to compete for your clients. I'm not calling your clients. And he says, I know that. I can tell you wouldn't do that. That's the way most people leave a firm. Then as soon as they leave, they call, say, I've left. Love it if you'd like to consider coming with me. You're not supposed to call them while you're at the firm. But I told them I wasn't going to call them either. And the Lippman and I had to offer our mortgages on our house. Of course, that required your mom's permission as collateral to borrow enough money to start a law firm. And it was, we were bringing two other people with us, and Jack Lever joined us shortly thereafter. So 6 people, and we got his secretary. And we had to do a business plan, and we had it set up so we projected we make a certain amount. Apparently, banks looked at that one and concluded they're a good enough risk. And I think it was based on my government experience as well as the 2 years that I had at Spencer and Kay, gave us the money, and we had to pay it back. And we had a big first year because I nailed a case right away. And also, we got our first client the second day we were firm because Soltex had a trademark case that they had had at my former firm that I was handling. And at Buckingham, the general counsel called me and said, we'd like you to do it. We've already talked to George Spencer. He knows that we want to transfer it. I said, but I told George I wasn't going to go solicit any of his clients. And he said, don't worry about it. And I called George, and George said, not a problem. So we got that client. It was a small case compared to the one I just told you about, the printer case. But that's how we started, and we did very well for a couple of years.
I've run my own business, my own practice, and it gets taxing, especially when you have 6 employees that you guys are like, you're responsible for, and when's the next case coming in kind of mentality, I imagine. So along comes William, Brinks, Olds, Holfer, Gilson, and Leon, and is there any more names?
No.
Did anyone ever talk to them about their branding? I mean, what kind of name is William, Brinks, Olds, Holfer, Gilson?
Well,
I mean, come on.
Yeah, I know, but the practice in law firms is to use the first 2 names.
I know.
So they always were referred to as William Brinks. Yeah, but I mean,
it just makes me laugh when I see something like that.
I mean, think about the poor receptionist. They have to answer with all those names.
Like that.
Yeah, I was at some firm in Los Angeles it was named Spencer Horn, Jubitz and Lubitz, and I'm sitting there in the lobby waiting to go in. And I hear Spencer Horn, Jubitz and Lubitz, Spencer Horn, Jubitz, and I looked at the woman. I said, that's a mouthful. I said, do you have to answer it that way every time? You can't just say Spencer Horn? And she says, well, you have to worry about who's listening. So we go the safe route, and we go Spencer Horn, Jubitz and Lubitz.
Oh, man. Okay, so tell me about
William Brinks.
William Brinks.
We did very well at Lupo and Lever, and we got to the point we were 8 attorneys and the staff and everything, maybe 30 people. And then all we did was litigation, and then all of a sudden everything we had settled, and not everything, but there was a period of time it was really tough because we weren't getting any money, We didn't want to fire our staff. We were paying our staff. We weren't taking our draws. And, at one point even it was close to 1983 or 84, 85, somewhere in there, close to selling my car, selling my darkroom, anything just to get through another month or two. I had an argument at the Federal Circuit, and someone in the back saw me argue the case and called me that day and said, I'm at Will and Brinks. We're a 125 lawyer firm in Chicago, and we don't have a Washington office. We'd be very interested in talking to you, especially with your International Trade Commission practice. That's how it happened. So we hired them. They hired us, I should say. They merged us, and that saved us. I don't know if we would have been lucky enough 2 months later to get another big case. Sooner or later we'd have had it, but would we have been broke and would we have had to lose staff and everything? So we were in Will and Brinks for 6 or 7 years, and then McDermott came after us, and McDermott made us a nice offer, and we were 16 lawyers at that time in the D.C. office, and there were problems at Will and Brinks, and we joined McDermott. So that's kind of the four-firm history. I brought 16 lawyers to McDermott to form their IP department, and when I retired in 2010, there were 245 lawyers in that department.
Whoa.
1,200 lawyer firm.
You were one of the top guys.
I was the top guy.
The guy. So did your role change from courtroom litigation to management and hiring and?
Yeah, no, I still did all the court. In fact, I had more trials and bigger trials because by that time your reputation's getting out and you're getting hired for some pretty big cases. But I also had responsibility to form new offices around the country. So I formed our Silicon Valley firm first on hiring IP lawyers. Also hired the first IP group in San Diego, hired the first IP group in Orange County, hired the first IP group in Los Angeles, Chicago, Europe, Britain, Paris, and this is over a 10-year period. I built it that way. Now I have to say, I don't make it sound like I'm the Superman here. Very significant in my career was my partner Donna Tangway. As well as, there were others, Jack Lever too. But Donna had an incredible ability to organize and oversee the litigations. And while I was on the management committee of the firm, and I was doing these other things, I was really hired to be the trial lawyer and make sure that we had a good strategy going in. So if I had a team of 20 lawyers, or 20 people, I should say, working on a case, I was responsible for the strategy early on to build that case down the road to try, and then try it. Donna ran that strategy and oversaw to make sure that everything was done on time, papers were correctly filed, and I had very talented people that I worked with, and that's a very important part of the success story that I had.
Yeah, you kept the same core of people.
20-some years.
Yeah, that's unbelievable.
Yeah.
Is there anything else you'd like to tell me about leaving the patent office?
Well, there are two things that I remember that were significant from a memory standpoint. Not in terms of the biggest cases I argued, but two things that happened at the Court of Customs and Patent Appeals. The first was I actually had a case for the Patent Office where involving a particular dispensing apparatus where the Colgate-Palmolive Company had been rejected on the particular idea over a patent that was examined by Raphael M. Lupo, who happens to be my father. He had retired by then. And when the record was up before the court, and I was arguing the case, I actually brought my dad to watch the argument. He was sitting in the back of the courtroom. And one of the judges, Giles Rich, who wrote the 1952 Patent Act, said, "Mr. Lupo, I noticed at page such and such of the record, the patent examiner who handled the patent that this invention was rejected over has Raphael M. Lupo. It's very similar to your name. Is that any relative of yours?" And I said, "Yes, it's my father." And he made a very nice comment. He said, "Well, that explains why you understand this area of law so well." And then he said, "Is your father here today?" And I said, "Yes, he's in the back of the courtroom." And he said, "Welcome, Mr. Lupo." And it was, I mean, for my dad, you know, this is this is a golden moment. He's raised a kid who a court has said nice things about, and his work that he worked so hard at as a patent examiner is the center of the case. So that was a nice moment. The other moment came on the very last argument that I was going to have in the patent office. I guess the solicitor's office had called over and said, "Lupo's arguing his last case today." And I brought your mom, and this is 1978, you were probably there, all four sons, to that argument. They sat in the back of the courtroom. I think it's probably the only time, one of the only times my sons have ever seen me in court. And at the very end of my argument, the Chief Judge, Markey, made a pronounced speech about the work I had done in the solicitor's office, the number of cases that I had had, the excellence of my presentations, and it was just, it couldn't have gotten a higher honor. And, you know, the court printed it out for me. I have it in my darkroom, actually. I think it might even be in the book, I don't know. But it was really a nice thing. And then Judge Rich had my family up to his chambers afterward, where they had a little buffet and a goodbye, you know, kind of goodbye thing, which was very nice. I mean, I had many cases before that court, after that, some for Energy Department and some in private practice over my years of practice. But those are two significant highlights. And that was as I went out to the Department of Energy. That's it.
Those are nice stories,
Yeah.
especially your dad. That's
Yeah.
cool. So, how many cases do you think you've done in your life?
Well, I've had over 200 appeals and over 70 trials. And that's quite a few.
That's a lot for a trial attorney. Most attorneys don't even really go to trial, right? They settle, or they kind of,
Well,
it's rare when it goes to trial.
It depends on what kind of law you're doing. Obviously, if you're a divorce lawyer, you go to trial a lot. If you're a tax lawyer, you probably go to trial once every several years. If you're a patent lawyer, usually it's once or twice a year if you're a litigator. And if you take, and I actually did over 70 jury trials, that's a ton. There were years I did 4 or 5 trials, and that's very unusual. As for the 200 appeals, that's extremely unusual. That's a very high number. And I only know one other person in private practice who's had more appeals than that. And that's Don Dunner, who's probably had 300 or 400.
And you've had some pretty groundbreaking cases. I mean, I don't think it's possible to go over all 200 or 70, but there's a couple that stick out that really changed the direction of law, especially for some people watching this who are more interested in legal history. What are some of the groundbreaking cases you did?
Well, I think one of the ones, although it didn't seem huge at the time, but it really was huge, was a Church of Scientology case. Church of Scientology was not a client of mine, but when I was at Will and Brink's, one of the attorneys there represented them in copyright and trademark. And there was a case where one of their members stole, according to the church, written text of the originator of the church and published it on the internet. And this is very early on. This is 19, maybe 89, 90, somewhere in there. And if you remember, that's a period of time before people were really using email, really using the internet. And the Church of Scientology tried to sue the person who has taken that technology and get the court to rule that it should be banned from the internet because it was a infringement of their copyright, since it was a written work. The fellow who stole it and had actually a paragraph of it published in the Washington Post was also sued, claimed that there's no copyright on the internet because all you're transmitting is zeros and ones. You photocopy it and you scan it, make it zeros and ones, send it to somebody as zeros and ones. They receive it as zeros and ones, and there's nothing original about zeros and ones. Well, Judge Brinkma in the Eastern District of Virginia got the case. I was the only Virginia candidate at that, or lawyer at that time, in the Chicago firm, so I argued it and handled it. The case was significant consequence because if the court agreed with the Church of Scientology that, with the defendant, that there was no copyright infringement by using the internet, everything that anybody ever wrote, music or otherwise, could just be copied and put on the internet and there'd be no protection. Brinkema had a husband who was interested in the internet at the time. Most of us knew very little about it and how it worked and what the consequences were. But fortunately, because I believe of her husband's interest, she took an interest. And she ended up ruling that it was protectable material. So that was a very significant decision.
Yeah, because if that case had gone the other way, then since the concept is if I take a picture, that this picture is not really being copyrighted because I'm converting it to a stream of data that's not exactly the picture.
Correct.
It's just being ones and zeros. So you could use that argument for anything on the internet. That
Anything.
There would have been absolutely no copyright at all that could be protected because it's not technically that picture. So it's an interesting decision. So that's a big deal with the Scientology case because you're talking about, for you guys that don't know much about the Scientology, they have you have to pay to see different classes as you go, and you have to pay an enormous amount of money to see the very top private writings. So that guy was mad about that, took the top private writings and posted it for everyone to see, so he didn't have, like if you're just a layman, you don't have to spend years of your life and $200,000 to see it. I would imagine that would have made the church really mad.
Very mad. And this is a controversial religion to begin with. And there are very strong feelings on both sides of that religion, as there are in many religions. But the writings, because of what you just said, were a source of income, because each member had to pay a certain amount to read the next step toward I think there were 10 steps. And at that time, 1990, I think it was 10,000 to read each step. And so when somebody posts whether I don't remember if he posted all of them or just one or two, but to them it was a big threat, because even if it was just one, anybody who could get in there to see him would be taking it out and copying it. So that was a big case, and you have to talk. Your question asked me about cases that have changed the law. You can be a very successful lawyer, trial lawyer or appellate lawyer, and never change the law. The question is whether you win for your client. If the client is trying to stay in business in a patent case and you're representing them and someone is suing and saying that they infringe your patents, your client just wants you to win so they can stay in business. If you're representing a patentee and somebody is ripping off the patent and fighting you in the marketplace, you want to win. And so you can block that person from making the product illegally or have them pay you royalties. So when you ask about cases that actually I was involved in change the law, the Scientology case is a big one. There's another one. And that was just a few years ago, 3 or 4 years ago. I argued a case before the Federal Circuit, where the Federal Circuit is the patent court in the United States, just below the Supreme Court. And the Federal Circuit heard it en banc, which means all the judges of that court, all 12 of them, sat and heard the argument. Usually in an appellate case, only 3 hear it. And so the question there involved law that the Federal Circuit actually made that had been used over and over for 25 years. And I argued that that law should be changed because the issue that it involved was being abused by patent owners because they were overextending what the court had said earlier. And without getting into a lot of boring details, it's not easy to understand. It was a huge case. And the court overruled its own law of 25 years based on the arguments that I made on behalf of our client, which was Seagate. Seagate makes disk drives. And so that was another law-changing case. So I've had at least 2. There are probably 1 or 2 others that I'm not thinking of now in my career, and that's very unusual.
And for you guys listening, he's too humble to say it, but he was one of the best patent attorneys in the whole country, probably in the top 3 at some point. And you probably had some pretty huge cases that other people will never see that in their lifetime, I don't think. You had some big cases.
I had some very big cases, and I don't know if I was in the top 3, but certainly in the whenever there was a big case being something that involved a couple $100 million on the line, or a company staying in business, there's maybe 5 to 8, maybe 10 attorneys in the country that originally came up on the list that a company would consider hiring. More complicated issue is once you get that 8 or 10, does the law firm they represent have a conflict where you don't want to ask that attorney to represent you? So you select an attorney who you think is best able to win your case, and that attorney has to be from a law firm that doesn't have a conflict. So I've been lucky enough to represent major cases for Kimberly-Clark for quite a few years involving the diaper industry against Procter & Gamble, Huggies versus Pampers. And that was a huge battle going on in the 80s and 90s between those 2 companies that cost them millions and millions of dollars to just fight in court, because obviously the diaper business is big. Years later, I represented Medtronic, which is the world's largest maker of medical devices, including stents, heart valves, defibrillators, pumps for diabetics. And for 4 or 5 years, I was their main representative in a bunch of cases, maybe 15 or 20. Many of those were against Johnson & Johnson in the stent business, as well as Boston Scientific. And then in the computer field over the years, I represented National Semiconductor and other companies against usually Intel and sometimes Microsoft. And so those are big cases.
What's the largest judgment you can remember working on that your team won?
Well, that's kind of hard to say, but I would guess just winning a diaper wars case meant over the next life of the patents, plural, could mean several $1 billion. You know, because you sell $200 or $300 million worth of diapers each year, and that's a small number. And you multiply that up by 10 or 15 years, that's a lot of money. The same for Medtronic on their stents. And you know, those are the big cases that you have for companies. Not necessarily the ones. If you ask me what were the cases you enjoyed the most, what do you look back on and have laughs over? That's a whole different issue.
Yeah, because we were talking, and you said in your career that the most important cases weren't the big number, big dollar cases. That you had cases where you saved people's jobs. You did stuff that, let's talk about those. What are the cases you remember that you feel like you did the best?
Well, certainly for a fond memory, and I'm kind of illustrating the 6 degrees of separation idea. I had a case involving a small company, a family company in Minnesota called Miller Waste. And Miller Waste made long plastic fibers. Maybe if you took something this big around, there'd be 100,000 of them. And they were made in the plant, and then they would be used for melting to make bumpers on cars, dashboards, things like that. They were sued by Kawasaki, Japanese company, who had bought some British patents, and Kawasaki was trying to knock them out of the business. Well, Miller was a $100 million or $80 million a year company, of which maybe 40 to 60 million of it, over half the percent, was this one product. They made other things, but basically it would have knocked out a major part of their business, family business. They were very good people. They've been very good to their employees over the years. I had a fun trial where I got the actual inventor for Miller, who had invented a product, the product that Miller used earlier than the Kawasaki patents, which meant the Kawasaki patents shouldn't issue. Kawasaki brought the British inventor over, and he wasn't particularly very nice in front of the jury when I asked him to take some of the fiber form and show the jury to explain it. He just jumped out and said, "No, I wouldn't touch that stuff. I don't want to get that fiber on my hands." When I put our witness on, who was just your average, really good guy, who even had grease in his hands from working on his car, he not only picked it up and was so proud to show the jury, he had a little model that he had made, wooden model, in his basement to test it, and he'd used his wife to run the plastic out while he was winding it out, and running it through the heating system. So I put his wife on the stand too, and she brought a scrapbook, showed how they formed a little company. Miller had given them permission to form their own little company to make this product, as long as Miller got the right to use it. So Miller was very generous in letting him develop it, even on their time, using some of their stuff. And here's this guy who comes down and hand it to the jury so they can pass the model. His wife has a scrapbook. I pass that to the jury. A very human case, okay? So why is this? Why am I going in this detail? It was a fun case to win in the court. So I win the case, but that's not where the story ends. Years later, when living over in Queenston in Springfield, on a cold winter morning, I drive up to the store, and I go into the grocery store, and I'm in there a half hour. I come out, the car won't start. So I need a jump start, and I'm looking around for a jump start, and there's this couple coming out of the grocery store, hopping in their Ram truck. So I went over and I said, "Do you mind giving me a jump start?" "No, not at all." So the guy pulls over and he's hooking up the cables, and I'm talking to the woman. And I just made the comment, I said, "This is damn cold out here. This is really cold." She's "Not as cold as where I live." And I said, "Where do you live?" And she says, "Well, where I'm from." And she names the town in Minnesota. Miller Waste was the company I represented. I said, "I know that town very well. I spent a lot of time there handling a case that I had." And she said, "What do you mean case?" And I said, "I was a lawyer, and I handled a case for Miller Waste." And she says, "Oh, my dad works for Miller Waste." "And what case was that?" And I said, "Well, it was a case involving the plastic material that they made to put into bumpers and everything else." And she says, "You saved my dad's job. He was head of the production line that made that." So that was really,
That's nice.
yeah, it made
Yeah.
a small company, family owned, that hired people that did good work, and her dad's job was saved by winning that case.
I think one of the biggest cases I remember from my childhood was Tandon Computer. Now, was it Tandy or Tandon? I can't remember.
Tandon, Tandon.
Tandon Computer, right before like everybody had computers, one of the first places you could get a computer was Radio Shack. That was at the malls. They'd have their brand that they pushed out was Tandon. So before, like, everybody had Apples and IBMs, Tandons were around. And I guess, tell me how you were involved with that, because it was a big deal. We were the only people I knew on the block that had a computer, because you got one for work. You had to see what a Tandon was.
Yeah, we had one in the house, that's right. And I had no idea how to use this damn thing. It was 1986. I have an electrical engineering degree, and I have no idea how to use that computer. You had to use DOS back then. It wasn't like using Microsoft Word or anything else you use today.
There was no mouse, and you had to steer it through the disk drives.
Awful. But anyway, the point is that the personal computers for the home were just being introduced. And Juggy Tandon, an American initially from India, and his family, Juggy invented a double-sided floppy disk drive. Now, you may not even remember that, but original computers, you had a slot, kind of like you now still have for inserting DVDs, but you had a slot, and you'd put this floppy disk in it, and then you could load something down on it, but it was very limited. It's 256K. Juggy invented a floppy disk drive that worked on both sides of the floppy disk that doubled the storage capacity. He was selling these things like crazy to computer manufacturers, Compaq and others at the time. He had the market. He had them made in India, and he was making a very nice profit off it. And Tandon Corporation was probably in 1980s dollars making several hundred million a year. All of a sudden, at the computer show that year, whatever year it was, 13 Japanese companies show up with floppy disk drives, and they're flooding the market shortly after that and selling them for $50, $55, less than Juggy's expense for making them in India. So he did some research and got my name. I was interviewed with other firms and got the job of suing them in the International Trade Commission, which also has a patent program that stops illegal imports. And if you infringe and you import, that's illegal. So I sued for Juggy, those 13 companies. There were 3 of them initially in the lawsuit, Sony, Mitsubishi, and TIAC, and got what was called a preliminary injunction 40 days into it that they had to stop putting their product in the country. That immediately brought all but one of the Japanese companies to the licensing table, and they licensed Juggy's patents. So he made plenty of money, gave them permission to make it, but saved his products. The one that didn't was Mitsubishi, who argued that their device had been designed so it got around the specific wording of Juggy's claim. And in fact, on appeal, they won at the ITC. ITC let them out, and on appeal they won. But, so was it a victory? 12 of the 13 companies were a victory, and a lot of money, and saved Juggy's company. And it was a victory, even though one company got away. The irony was, even though Juggy got those licenses and made a lot of money off it, years later he himself started making computers because computers were really starting to hit the market. Microsoft came out with Word somewhere in there in that time frame, and you just had to join the fast train if you were going to go, reach the destination. So that's it.
Did he ever come back to you for other cases, or?
Oh, he never had another case. He was a very rich man.
So he just sold off his stuff.
He sold off. I forget.
Kicked back on licensing.
I forget who bought his company. Probably one of the other.
I think IBM probably maybe folded in Tandy. I don't know. And then, is there any other cases or?
No, I think that's probably
good for right now.
Yeah, because we could spend months talking about cases, and I don't want to do that. The bottom line is that I really enjoyed trial work. I had great people that I worked with. I could not have had the career I had without those people. I mentioned that earlier to you, and who those people were. I won't repeat the names, but it's a great career. I guess I could mention you're going to come up in the Memphis case, I suppose.
We'll briefly mention that and get into it later more.
The last big case I had was in Memphis, and it was the biggest kind of case that my law firm ever had, biggest case that Medtronic ever had. And I guess it's the point just to say I didn't finish the case because in the 5th week of the case I got hit by a car crossing the crosswalk, and so I was out of that case. I would have liked to have finished it. It was we had 16 attorneys and the other side had 26. It was a lot of fun.
How did that case end? Do you remember?
The case ended with a settlement. Depending on how you view these things, the client thought that if it got out a certain way, that it won. It got out that way, even though the trial was not won.
Right.
That's
what happens with law. It's not a slam dunk, but you get away with something you're happy with.
But I like to say that I won every jury trial I ever had. But I have to add that I finished. Because I didn't finish that case and we lost it.
But then after, your career didn't end at that because you kept coming back, and then I should say you got into, it's not judging, avocation?
Yeah, and before...
So there's a section of that too in your career.
Before I even got to that, I had that big case that I told you about, Seagate, at the Federal Circuit. I was still arguing appeals. I was still involved in some of the Medtronic cases that I had. I just didn't try them.
So the accident ended your actual trial work, but you still kept on doing other legal avenues.
That's correct.
And what were you doing up until about last year or two? It was some sort of advocacy.
Well, I was asked to be a special master.
That's what it was.
Yeah, a special master in a big patent case involving 4 patents, and the Judge Grimm in Maryland, it was his first patent case, and when he saw the complexity of it, and it was involving software and banks and how all kinds of information, how it's stored, he said, if you want this case done in any quick time, you're going to have to get a special master. So he told the parties that they had to come back with a name of somebody that they both agreed could be a special master. So what is a special master? Well, first of all, the parties submitted my name. And that's kind of interesting because on both sides, it's a big case, there were attorneys that I had worked with as co-counsel in cases and attorneys I worked against on both sides. So it was really, a very high level of respect that they would pick me as someone honest enough that they think would be honest in performing the judging role. And the special master becomes the judge. In essence, I handled the entire patent case with 2 more than helpful people. And the 3 of us wrote all the decisions. I was responsible as the special master for the final product and signed it. But I had tremendous input from the 2 of them. And then the judge at the final decision decides which of my recommendations he will adopt as his. He writes the opinion off of whatever I've done. So he doesn't completely escape the final thing. And that case is currently on appeal. Both sides liked some of the stuff that I did and the judge did. And when you win some and you lose some, you got to be very careful about what you say about the judge or the special master. Because if you say he's an idiot, well, what about the time you won? Is he an idiot when you won? So it was a lot of fun. It was a lot of work. And
now, do you think you continue to keep busy doing something like that? Are you at the point in your career where you're just done with legal stuff, or would you like to have some more work?
I'm at the point in my career where I'm 95% done. If something walked in the door, I'm not looking for it. But if something walked in the door interesting, you know, I've been an expert witness, I've been an arbitrator, I've been a mediator. I almost mediated a case.
Probably.
Consultant. I'm not searching for work anymore. I like retirement. And I wasn't searching for work when that special master case came in. It turned out to be a huge 9 months of work, but I'm happy.
Yeah. Stick with us as we roll into the next chapter. Hopefully it just automatically plays the next chapter unless it's not finished yet. It does take me a little time to make these things. So if it's not up, just keep coming back and until it is here. So I'll see you over there.